What does physical presence on account of trafficking mean under USCIS Section 101, A, 15, I2? Trafficking survivors seeking protection in the United States must prove their current presence is directly caused by the trafficking they endured. Under INA Section 101, A, 15, I2, a T1 visa applicant must be physically present in a qualifying location on account of trafficking at the time of filing. This requirement involves more than simply being in the United States when you submit your application to USCIS. You must demonstrate a causal connection between your trafficking experience and your current presence in a qualifying location. Qualifying locations include the United States, American Samoa, the Commonwealth of the Northern Mariana Islands, or a port of entry to any of these areas. A principal T1 applicant physically outside these areas at the time of filing generally cannot establish the physical presence requirement. The phrase "on account of trafficking" requires proof that your presence in the United States is connected to your trafficking situation. Being in the country for an unrelated reason does not satisfy this element, even if you are also a trafficking victim. This connection may be shown through current trafficking, liberation by law enforcement, escape before law enforcement involvement, or past trafficking that directly relates to your current U.S. presence. The trafficking does not need to have occurred entirely within the United States to meet this requirement. A person recruited through fraud in their home country and transported to the United States for forced labor may meet this standard when the trafficking caused their U.S. presence. You do not need to still be in the trafficking situation at the time you file your application. The key issue is whether your current presence remains causally connected to your trafficking experience, including situations involving liberation or escape. If you voluntarily left or were removed from the United States after the trafficking ended, the physical presence analysis becomes more complicated. DHS regulations generally treat applicants who left as not physically present on account of trafficking unless an exception applies. An exception may apply if your re-entry resulted from continued victimization, a new trafficking incident, participation in a trafficking-related investigation or judicial process, or a return to receive specialized treatment unavailable elsewhere. A T1 application must include Form I-914 and a detailed, signed personal statement addressing the trafficking you experienced and how your physical presence relates to that trafficking. USCIS considers any credible evidence when evaluating this element, and no single type of corroborating document is required. The strength of your application often depends on how clearly your evidence tells the story of how trafficking brought you to, or kept you in, the United States. Consistency across your personal statement, supporting letters, and any law enforcement documentation is critically important to USCIS reviewers. Form I-914 Supplement B, a declaration from a law enforcement agency, is optional evidence that may help support victimization and the connection between trafficking and your current presence. USCIS still decides eligibility independently, and the law enforcement declaration does not receive special evidentiary weight in the adjudication process. A strong application typically combines multiple types of documentation, including personal declarations, law enforcement cooperation records, and supporting letters from service providers. Call Shankar and Associates PC at 800-461-1467, located at 518 Plainview Road, Plainview, New York, 11803, to schedule your consultation today.